I think a lot of people don't think about the employee handbook as an important aspect of running a business. But the policies in place in an employee handbook and the procedures laid out in those handbooks, as long as they're actually followed by the employer, can really work to protect you on the back end should some sort of a claim arise. Hello, and welcome to A Higher Law, a cannabis industry podcast presented by the Dykema law firm. I'll be your host today. My name is Brett Gelbord. I'm a labor and employment attorney in Dykema's Detroit office. And as part of Dykema's cannabis industry group, I provide labor and employment counseling to businesses in the cannabis industry. Sometimes people think of that as the legal side of HR, and that's part of what I do in terms of day-to-day counseling with respect to issues that may come up regarding individual employees and setting employment policies. But I also represent clients in employment litigation, and that might mean defending against a claim of wrongful termination if a person feels that they were fired because they are part of a protected class, or if they feel that they were terminated in violation of the provisions of an employment agreement. I also will affirmatively seek to protect a client's rights under non-competition and confidentiality agreements through demand letters and, if it comes to it, litigation. Now, I see employment law in the cannabis industry through three lenses. The first lens is general employment issues that are applicable to all employers, regardless of the industry, that aren't getting the type of attention that they deserve and that they need. The second lens is cannabis industry specific issues that flow from the regulations themselves in a given jurisdiction and from the specific setting of a cannabis business, whether that's the ins and outs of what's going on at a grow operation or a cannabis retail setting or anything in between. And the third lens that I view the industry through is cannabis legalization more broadly as it impacts our nation and employment practices, generally speaking. And that looks like counseling clients typically outside the cannabis industry about drug testing policies and those types of things. For the purposes of today, we're going to talk about those first two lenses. So turning to general employment issues that I believe are being neglected by cannabis employers, we talk about why those issues are being neglected, because I think there are understandable reasons why that might be the case. And I think that they're being neglected because a lot of these businesses are operating in what could be considered startup mode. And so they're very focused on getting operations up and running, making their businesses profitable. They're also very focused on complying with the regulatory framework in whatever jurisdiction they're working in. Those are very important things to be focused on as a business owner. Unfortunately, as a result of that focus, these sort of background employment issues sometimes fall to the wayside. And what am I talking about when I say background employment issues? Well, first you have a whole suite of employment laws at the federal level that do apply to cannabis industry employers, notwithstanding the fact that the industry remains subject to federal prohibition. Federal employment laws still do apply. And so you're looking at things like the Family Medical Leave Act. If you employ 50 or more employees, you're going to have to comply with that. You're looking at the Fair Labor Standards Act, which sets minimum wage and overtime guidelines and has provisions for classifying individual workers as employees or independent contractors. And there are real penalties and significant risks associated with misclassifying an individual worker under that statute. There are reasons why an employer may choose to classify an individual worker one way or the other. Often it's seen as a cost-saving measure to consider someone an independent contractor, but the risks associated and the potential financial penalties involved often outweigh any savings that you may see in the short term. So it's important that you have your workforce properly classified under federal law. There's also union issues. The National Labor Relations Act applies. And it's no secret that unions have been approaching workforces in the cannabis space nationwide with varying degrees of success. It's very important that you consult with a experienced labor attorney if you learn that your workforce has been approached by a union, because there are very specific rules about how you can and can't address those issues once the topic has been raised. And the last thing that you want is to be defending yourself against the claim that you've unlawfully interfered with your workforce's right to unionize. So those are some federal statutory background issues that really should be on every employer's radar in the space. It's also important on not a statutory level, but just from a policy standpoint, that you have employee handbooks and employment policies in place that are well thought out and that actually apply to the business that you're operating. I have seen in this space employee handbooks that were just downloaded from the internet that haven't been customized to reflect an actual workplace. And the risk that you run with that is you lose the protections that you might otherwise have from having appropriate policies in place that you are actually following as an employer at an institutional level. Now, many of us have taken jobs and you're handed an employee handbook and you sign it and you don't read it and you just go about your day. And so I think a lot of people don't think about the employee handbook as an important aspect of running a business. But the policies in place in an employee handbook and the procedures laid out in those handbooks, as long as they're actually followed by the employer, can really work to protect you on the back end should some sort of a claim arise. And a good example of that is, say you have an employee who claims that they were subject to some sort of sexual harassment in the workplace, and they turn around and sue the employer. They're suing your company and they're saying that you should be responsible because they were sexually harassed. If you have an employee handbook that you didn't really customize, that you aren't following the procedures laid out in for dealing with those issues, you're not going to have as strong of a defense as you could have in court if you can say to the judge, well, Your Honor, we have an employee handbook that very specifically states that no sexual harassment will be tolerated in the workforce. The alleged harasser signed this employment policy, understands it, and so was acting clearly in violation of our policies. And also, we have procedures in place for victims of sexual harassment to report confidentially that there's been an issue, to investigate those reports, and to take remedial action if necessary. We have all of those procedures and policies in place. The victim here was aware of these policies and procedures. He also received the handbook and signed off on it. And no reports, confidential or otherwise, were made to the company about this situation. The first that we heard of it was the lawsuit, Your Honor. Those kinds of arguments carry weight in court in these types of cases, and they can also help lead to a better resolution if you're mediating or settling the matter. Another issue that I see in the cannabis space has to do with employment agreements. Now, this is another topic where businesses are rushing to get things going. You're hiring people very quickly, and you don't take the time to have somebody experienced in drafting employment agreements take a look at your agreements. And you can wind up with employment agreements that don't have the right types of protections on the back end for the employer. It's possible, and I have seen employment agreements that have no guardrails for severance obligations, for example. And in the current state of the industry here in Michigan and in many other states, businesses are struggling with falling wholesale prices and are taking cutbacks. And there are businesses that are saddled with heavy severance payment obligations, because the severance provisions in their employment agreements do not provide the types of protections that you would typically see in a well-drafted employment agreement. And, for example, you'll often see a scaled up or tiered severance package where If a person works for 1 year, then they're entitled to 1 month of severance. If they work for 2 years, then they're entitled to 2 months of severance. I've been seeing employment agreements in the space that don't have any of those protections and that are resulting in massive severance obligations. Those are several general employment issues that really need to be addressed and that employers should keep an eye on as they develop their businesses in the space and continue to grow, hopefully, despite the current market conditions. Now, the second lens that I mentioned, cannabis industry specific issues, range from employment-related minutiae, really, found in the various regulatory scheme works across the country, to more significant regulatory issues potentially implicated by employment relationships. On the minutiae level, you've got identification card rules. Now, Michigan doesn't have anything too specific on this topic, but I was recently counseling a multi-state operator on their employment policies, and I found that in 2 of the other states in which they operate, there are very specific rules about what kind of photographic identification employees have to wear while on company business. The states differ in what they require to be in the ID cards, and it's a simple thing to comply with as an employer, but it's easy to overlook it, and it's easy to not have it in the policies so that you can say, hey, worker A, you don't have your ID card on today, you need to go home, or you're going to be terminated because you're putting us out of compliance with our regulations. So that's an example of something fairly minute that someone who's not well versed in the space might miss, providing just general employment counseling. Another example of that in Michigan is we have some restrictions on working for more than one type of licensee as your employer. So if you work for an employer who's a secure transporter, then you can't work for certain other licensees at the same time. Those are things that really need to be kept in mind when hiring and when maintaining your workforce. And some more important regulatory issues that come up, or they're all important, but some, I guess, higher value ones have to do with issues of ownership and individual qualification under the various states' regulatory frameworks. For example, in Michigan, if a person owns 10% or more of a cannabis licensee, that person needs to be qualified by the state regulatory agency, the CRA. And this comes up in the employment context because oftentimes when you're negotiating employment agreements for higher level employees, there will be an equity component that's often put in as a bonus or some sort of profit sharing scheme. And you need to make sure that whatever you put into that agreement either doesn't cross that threshold and cause that person to need to become qualified by the state, or if it does, you need to make sure that that person is qualifiable and that they get everything lined up so that it can happen fairly smoothly. Well, that's it for us today. Thank you for listening along. And you can find us at youtube.com/ahigherlaw. And once again, my name is Brett Gelbord, and I look forward to seeing you next time.